We'll get started with the subcommittee meeting in, if I can have everybody's attention, we'll get started with the subcommittee meeting in just a few moments. In the meantime, there's a sign-up sheet on the table on this end of the room. If anybody wishes to speak, we will be hearing two bills today. I think House Bill 72 has been removed from the agenda, so we'll be hearing the other two bills. I don't have that paperwork right in front of me, but the other two bills will be on.
374.
Yeah. Okay, we will now begin the subcommittee on state and local government for the Governmental Affairs Committee. Appreciate everybody coming in today. And the first bill we're going to discuss today will be House Bill 374 with Representative Thomas. Representative Thomas, we'll let you take it away.
Thank you, Mr. Chairman. House Bill 374 creates an alternative method to de-annexation. I actually carried this bill originally last session. It was HB 1439. It had a hearing. One of the major pieces of feedback I got was the original 1439 didn't carry the 60% method, so we added the 60% method back in. I think a couple things worth noting is it still allows for the standard methods of de-annexation, being through the city and through the General Assembly, with one small change. It does require the adoption of a resolution by the county. I think that, and that's specifically on line 5051, page 3. And I think that has to do with service delivery. I think that's just a good thing in general. If someone's going to de-annex out of a city, they probably should make sure the county is okay with doing the service delivery. So, additionally, it requires payment for any bonded indebtedness that's created. So those people that live in that area, those parcels that are being de-annexed, they will have to pay taxes. It creates a special tax district. It does that in lines 96 through 108 on page 5. Additionally, as I said before, we added the 60% method in, so it still requires a resolution adoption by the county. That's on page lines 215, 216, page 10. And it does so because, again, we want to make sure that we're doing what we need to do for service delivery strategy and agreements. Additionally, it allows, the 60% method includes a arbitration panel that's identical as the annexation arbitration panel. So if a group of this, and this only applies to the 60% method, if, say, a large group, they want to de-annex through the 60% method, then they would go through, they would have a referendum. The referendum would get voted on. At that point, the cities would have an opportunity to go to the county, and they can actually fight that out in the standard way that they do it on the annexation 60% method. So it's really parity between the two, the annexation and de-annexation. They're really parity with the parity with the exception of the 100% method. So I'm going to bounce back to 100%. On 100% method, One of the specifics is I did try to allow for some opportunity to object to that process just in case. And those are really health, safety, and welfare of the residents and property owners of the area to be de-annexed. If there's an issue, then the city could, they could object under that reason. So I'd be more than happy to open up for any questions. That's the base run of it.
Okay, thank you, Representative Thomas. We do have a couple of questions. I think Representative Bernal.
Thank you, Mr. Chairman. I remember this bill from last year, and I remember that there was something on here about that if the residents, those that wanted to de-annex, would have to get their own attorney. Do you remember that discussion we had about them?
I've slept a couple times since
Okay.
then.
Well, it was something about that they would have to pay for their own attorneys to de-annex.
Well, I think that's probably appropriate. I mean, if someone wants to de-annex, they should cover their own legal fees. So, but I'm not familiar with the specifics of what it is that you're talking about.
Okay, I'm gonna go back and read it through very carefully, then I'll be able to ask
Yeah,
you.
we got
Okay.
time.
All right, thanks.
Representative Williams.
Thank you, Mr. Chairman. So I'm thinking about the Mableton situation, city of Mableton, where we have a fairly large number of people who want to de-annex. Is this a procedure that would be applicable for those folks?
I can't speak to the specifics of a situation I don't know. Here's what I could tell you: one is what this bill does is it basically holds municipal governments accountable, and it does so by the way of, I could think the best way to say it is when you annex into a city and you want to de-annex out of a city, you have to go to the same people you asked to get let in to get let out. That just seems wrong to me. What this does is it actually sets up an alternative option, and that you go to the county government. Now, I want everybody to remember the county, whoever that is, usually Board of Commissioners, these are elected officials by these people who I would believe is, a neutral party that can listen to this and provide a fair and balanced opportunity for the case to be heard. Because it's really hard for somebody to say, well, now you're in, you're in. And I'd also like to mention the state government recognizes that de-annexation is something. It's not like, the United States where we're indivisible. I mean, cities can annex and de-annex. So this is just an alternative method. It just adds one more way of doing it.
Okay, thank you.
Yeah.
Thank you, Representative. Any other questions or comments on the part of the committee? All right, seeing none. Thank you, Representative Thomas. We do have a few people signed up to speak to the bill. First, I'll call up Mr. Todd Edwards. If you'd like to just come to the podium, introduce yourself, and proceed.
Thank you, Mr. Chairman, members of the committee. Again, I'm Todd Edwards with the Association of County Commissioners. ACCG asks for your favorable support on House Bill 374. I think the author did a pretty good job explaining the outline of the bill. We've been interested in this legislation for some time. There's always and has been traditionally a lot of conversation at the General Assembly about city incorporations, annexation. I know last year was major legislation, and recently the annexation arbitration process. At the center of these debates is which form of or level of government best suits the citizens, which offers more efficient services, more favorable, denser zoning, land use, or greater self-determination. Much has also been heard about respecting individuals' private property rights. So in recent and past annexation discussions, we hear that citizens ask to be annexed. Cities don't go out shopping for them. We hear property owners have the right to petition a city for annexation without a county being able to block it. Annexations are the natural way cities can accommodate landowners who want to be served by local government. And Georgia annexation law is based about individual choice. But once an individual is annexed, should those arguments still ring true, or should they be any different? Under current state law, you can ask a petition a city to be annexed. You can be annexed without the county's permission or consent. But once you're in there, you cannot get out or de-annex without the city's consent. And that's what this legislation is all about. Now, you can, I guess, go through de-annexation through the local act. That trumps everything else. But an individual citizen cannot de-annex from an incorporated municipality without that city's consent. This bill tries to address it, as mentioned before, both through the 100% and the 60% methods, as we call them. I will get to a couple of questions that were asked on Mableton. Sure, if the city was established, they had their boundaries rather than having to go through a local act to de-annex any particular portions. I know it's a hot topic, but this would give citizens the ability to do so. But there are some safeguards in there, and I do want to talk about those. So, again, it makes pretty much similar the act of de-annexation and annexation across the board. De-annexations would not be automatic. As the author spoke, you would first need a county's permission to make sure that they could provide services prior to the de-annexation. The use of the same dispute resolution process is currently in place for counties who wish to object to an annexation. It prohibits unincorporated islands. So in Mableton, we'll say, for example, someone in the middle of the city could not just annex their property. They would have to abut contiguity, same as under the current annexation process on the boundaries. Cities could continue to provide water and sewer service. In fact, they could charge 2 to 3 times as much now that they're in the unincorporated area, which is common practice for cities, at least twice as much, serving unincorporated areas with their water and sewer systems. They've got effective tax dates, that take into consideration schools with independent school systems, addresses bond indebtedness. It goes on with the protections. In the interest of y'all's time, I won't go any further, but I'll be happy to answer any questions. In short, we believe it just makes equitable the process of de-annexation similar, mirroring annexation law. We believe there are protections in place. There's a dispute resolution process. We would urge your favorable consideration, and again, I'm happy answering questions if y'all have any.
Thank you, sir. I do have one light flashing here. Representative Burnell.
Thank you, Mr. Chair. What reasons do they have to give for wanting to be de-annexed? Because I know with cities, we had one city that said they wanted a park. So what are some of the reasons they would have to give for de-annexing?
I don't know if the reasons are cited as must be given, but I can imagine what some of them may use. Perhaps they annexed into the city some years ago or promised a certain amount of a higher level of services, so to speak. They weren't granted them. They might say, well, why pay these extra taxes, or it doesn't suit my individual, needs. Why can't I be able to de-annex without the city's permission? But I don't know that the city lists what conditions must be met, other than that the objections could be based, if it, from the city's part, if it negatively impacted the public health, safety, or welfare.
Thank you.
Okay, any other questions for the speaker? Seeing none, thank you, Mr. Edwards.
Thank you.
All right, and at this time, we'll invite Mr. Jim Thornton and Mr. Patel. Is he going to join you? Yes. Okay, thank you.
Thank you, Mr. Chairman, members of the committee. I'm Jim Thornton, the Director of Governmental Relations for the Georgia Municipal Association, and I'm joined by Rushi Patel, who is General Counsel for GMA. And we wanted to share the concerns that GMA and our member cities have with the legislation before you. I'm going to speak to a few broad concerns that we have with the legislation, and then I'm going to ask Rushi to drill down into some specific issues with the language of the bill. To start, I would just acknowledge that for many years, the bias of the General Assembly has been towards effective planning as it relates to local government. State policy has encouraged cooperation and negotiations between cities and counties. The result of that has been comprehensive planning requirements, periodic service delivery negotiations, and ongoing consultations between cities and counties. This is necessary because Georgia is a very complex state. We have 159 counties, we have 537 cities, all of which are members of GMA, and each individual context and situation is a little bit different. But the General Assembly has been very thoughtful in encouraging discussions requiring annexations and de-annexations to be considered on an individual basis, and allowing all of the affected parties, the cities, the counties, the residents, the landowners, to be part of that conversation. What I think I would like to emphasize today is that de-annexation is very different from annexation. They are very different processes. This bill and the testimony you've heard attempts to portray annexations and de-annexations as comparable and to mirror the process. But that doesn't actually level the playing field, because there is a fundamental difference between when a city and a county engage in annexation or de-annexation. In both instances, the land always stays in the county. That never changes. The county retains taxing authority over the land, collects property taxes, often at the same millage rate from both city residents and unincorporated residents. And while counties typically provide all services to unincorporated residents, only some of those are provided to the incorporated residents. But the analysis is different for a city. In the case of an annexation, the city acquires a new role, and typically the reason for that role is to provide a higher level of service for the residents, but the residents don't leave the county. Cities normally accept many, if not of the service, most of the service delivery responsibilities. In a de-annexation, the property and the residents actually leave the city. The city loses the taxation and regulatory authority over those areas that are de-annexed, and they don't lose the service delivery responsibilities, particularly if the city has provided utility services or other services to that area where the service obligation is likely to remain. So in those instances where a resident or a property owner wants to de-annex, they are able to request that. The city has an opportunity to evaluate and engage in that discussion to see what issues it might cause. In fact, data that's been collected by DCA shows that over the past few years, dozens of de-annexations have been approved by cities. So this does happen. And as was mentioned earlier, there's always the possibility of relief through a local act if for some reason a landowner or resident is unhappy with the process. Over the years, the General Assembly has shown a policy preference towards contiguity, towards shapes that make sense of cities. The General Assembly has disfavored unincorporated islands, spoke annexations, other weird shapes on a map that might exist in a city. The legislature passed a specific law to prohibit the creation of unincorporated islands. The reason for all of that policy preference has been service delivery, because it becomes very difficult for cities and counties to coordinate services when there are overlapping jurisdictions, when you're having to cross different areas to respond. That is why de-annexations have to be evaluated by both the city and the county when they are taking a look at this. Under the proposed legislation, this essentially gives the city a very limited role in objecting if there is a proposed de-annexation, and that could result in the impairment of the ability for that city to provide services to those residents most effectively. There are a few things, and as I mentioned, Rushi's going to go into some specific issues with the language of the bill, but I think there are a few things that should be pointed out the bill does not address, which we think are very critical to cities and counties for that matter. The legislation does not address issues related to lost distributions. Lost exists in, I think, 148 counties that collect a lost. It fails to take into account all of the factors that are resolved in those negotiations. The legislation does not provide a reimbursement to a city that they have incurred expenses in providing and maintaining infrastructure to those areas that are proposed to be de-annexed. Contrary to, I think, state policy of the legislature, this does not require cities and counties to consider their comprehensive planning. It makes it actually very difficult for a city to engage in meaningful comprehensive planning if there is the potential of property and residents being de-annexed, particularly on a large scale, without the city having an opportunity to be a part of that process. Similarly, it hinders the ability of cities to budget and plan for their financial future, and certainly the stability of the finances for our 537 Georgia cities is something that's quite important to us as a state. Cities would also potentially face higher borrowing costs if it became common practice for large areas to be de-annexed from the city without input from the city or without some consideration of those issues. While there are some attempts in the legislation, and Rushi may speak to this, to address general obligation bonds, there's a lot of other debt obligations that cities take on from time to time, primarily to provide infrastructure. And of course, the state constitution limits what city's borrowing authority is based on their a taxable value that the city can incur. But when cities do incur debt, when they do take out tax anticipation notes, the potential for a large-scale de-annexation would jeopardize the city's ability to repay those obligations, potentially resulting in a default. And we think that's an issue that would affect cities across the state, particularly as bond companies and other financial interests take a look at the stability, the financial stability of the state. Georgia and all of her cities and counties enjoy a very good bond rating because of the stability of the state, and we think that this is something that could cause instability as it relates to tax issues at the state, at the city and county level. So I'm going to ask Rushi if he can to speak to a few specifics, and then he and I'll both be here to answer any questions that you may have.
Thank you, Jim. Good morning or afternoon. I'm not really sure what time it is. Rushi Patel, General Counsel with GMA. And I'm going to apologize in advance because I am going to boil down into a little bit of the language of the legislation. And I think as the author stated and as Jim stated, is a lot of what we are seeing with this legislation is trying to replicate what we see in the annexation side of the law. And I think there is a problem when you try to copy and paste language dealing with one aspect and put it into another aspect. And so we're talking about annexation to de-annexation. As Jim explained, annexation is very different than de-annexation. And unfortunately, when you copy and paste, legal mistakes are made, logistical mistakes are made, and practical mistakes are made. And I'm going to go through some of these right now. So looking at the legislation, I just want to start on the first page. Lines 51 through 56 talk about the city being obligated to de-annex the property unless they can show that there's an issue of health, safety, or welfare of the people in the area proposing to be de-annexed. There's absolutely no consideration for the health, safety, and welfare of the people remaining in the city. That is a challenge because those people still matter. Lines 92 through 95 and 162 through 164 will allow for the creation of unincorporated islands. When you read that language, it seems to prohibit unincorporated islands. However, the current law prohibits unincorporated islands not just within one city, but between cities. And so what this language fails to do is it fails to prohibit unincorporated islands between cities. So, for instance, if you represented Sandy Springs in an area, a neighborhood that bordered Roswell, and was completely surrounded by Sandy Springs or Roswell, chose to de-annex using this process, they would become an unincorporated island. And that is an interesting choice. It also, as Jim mentioned, would create issues with spoke de-annexation because it does not clearly prohibit spoke de-annexation. There's actually language in current code dealing with annexations that prohibits spoke annexation, but that does not exist in this language. Jim did talk about general obligation debt, lines 97 through 99 and 244 through 247. As he mentioned, there are other types of debt and other types of financial obligations that cities can undertake. Revenue bonds. I'm sure many of you have at least watched my Georgia Bulldogs win many games at the Mercedes-Benz Dome. That has been financed by hotel-motel taxes partly. Now, if an area leaves and that hotel-motel tax revenue is no longer there, that obligation could be in jeopardy. Lines 174 through 189, this is a real big issue in this legislation. 174 through 189 tries to address service delivery issues, but it doesn't understand the service delivery laws in the state of Georgia. And there's been a long-standing precedent from 1976 that states that once a municipality begins providing governmental services it is authorized by law to provide, discontinuance of such services must be justified. So if an area annexes or is part of a city and has provided municipal services and then de-annexes, the city will have to prove that they don't have to keep providing services. So those residents in the now unincorporated area would get city services without paying the price. And that is a real problem. Lines 288 to 290, there are 21 independent municipal school systems in the state. There's not much consideration for how those students would be bounced back and forth. Not consideration for the bond obligations those school districts might have. Those are real challenges. Jumping backwards a little bit, lines 110 to 113, defines municipalities as cities that have 200 or more. This makes sense when you're creating a new city, but we have 50 cities in the state of Georgia that have less than 200 people. So that definition doesn't capture them. Now, I'm not going to complain about that because it means they're not going to have 60%, but this is the thought that was missed. Lines 144 through 146, this language talks about the city bearing the cost of a report and or a list. Now, this is taken directly from the annexation law, but in the annexation law, the city is the one trying to annex property. Here, why is the city bearing the cost of creating the list when they're not the ones that want to get rid of the property? It makes no sense. Let's see. Sorry. Kind of jumping around a little bit. Okay. Let's see. Lines 292 and 303 require the municipality to provide a description of the proposed zoning and land use of the property being de-annexed. Again, this is lifted straight from annexation law. When a city is annexing, of course the city wants to have a standard for what they are proposing the zoning and land use would be. But if the property is being de-annexed, that's no longer going to be in the city. The city has no proposal for what the zoning and land use is going to be when it's no longer in the city. So that needs to be cleaned up. Lines 313 to 325 allows the county to object to a city's denial of a de-annexation, but provides no burden on the county to provide services to the area being de-annexed. There's a whole section of the law called the Service Delivery Strategy Act. The Service Delivery Strategy Act requires cities and counties to review and revise, if necessary, service delivery agreements whenever necessary to change service delivery arrangements. Now, that might sound like that solves that issue, but it only requires a review. It does not require a revision. And a county could very easily say, okay, we're reviewing it. We don't want to revise a service delivery plan here because the city's providing all the services. We don't want to have to. So that is a real challenge. Again, a lot of service delivery issues with this legislation. Lines 326 to 329, cities are able to reject a de-annexation petition if it's detrimental to the health, safety, and welfare of the residents of the property being de-annexed. How is that standard determined? That is going to lead to litigation. That is going to lead to constant fights with this arbitration annexation process that is proposed in this legislation. And then I'm going to get to the arbitration annexation process. It may not be known by the members of this committee, but the annexation arbitration process in current law that the cities and counties go through is actually in current litigation, and it's before the Georgia Supreme Court. The constitutionality of the annexation arbitration process is being debated at the Georgia Supreme Court currently. It may be that by the time, if this were to pass, it may be by the time that it becomes effective, that whole process is void ab initio, that it's no longer any good because the Supreme Court could have ruled that it's not constitutional. So copying and pasting something that's being debated by the Supreme Court is not a great idea. Lines 463 to 467 literally state that the person applying for a de-annexation or if the city or the person applying for the de-annexation drops the de-annexation, then the county cannot change the zoning or land use. Well, that doesn't make any sense because the property will still be in the city. The county wouldn't have anything to do with the zoning or land use. These are a number of the issues that we're spotting just looking at the weeds of the language of the legislation. It needs a lot of work if you're going to create another process. We think that the process in the current law makes sense as Jim described. There are two paths. They can apply to the city. They can apply to the legislature. And speaking of the legislature, I want to give a good example of the problems that this could create. In 2015, a local act went through the General Assembly to de-annex a portion of a city that happened to have the city's water treatment plant. And it led to a lot of litigation between the city and the county that got the de-annexation. And part of that de-annexation led to litigation that talked about the city having to continue to provide services to the area that was de-annexed from the city. These are the challenges that are created. So there are a lot of service delivery challenges, and those really need to be contemplated before this bill moves forward, if it does. Thank you.
Thank you, Mr. Patel. Thank you, Mr. Thornton. We do have some questions, I believe, from the author of the bill, Representative Thomas.
Thank you very much. I appreciate your nice review of my bill. So I'm going to tell you, you've brought up so many different things. I think we're just going to spend some time and go through them one by one. First of all, I want to talk a little bit about loss distributions with regards to reimbursement bonds. You had talked about that. If my understanding is, actually, I'll tell you what, I'm gonna dial it back even farther than that. So it sounds to me that the argument that you're making against this is predicated on the fact that there's a concern that there's going to be a mass exodus out of the cities the second that this alternative method is approved. And if that's the case, and if you're predicating everything on that, then doesn't that in and of itself tell me that there's because my issue with this is it's really about property rights, and it's about transparency. It's about the mom and dad who were annexed in. They were at 100% method. They annexed into a city, and they said, hey, I don't want to be here. I'm not getting the services that I was promised. That was the whole foundation of the bill. So I guess, like I said, getting back from the beginning, we could start talking about revenue bonds. So you said, well, you're going to lose revenues. Well, if you're providing the services to the hotel and you have the security in the hotel that is doing the things it needs to do, then I don't see any need why they would de-annex. And that's what this is about. This is about, that hotel that isn't getting what it was promised, isn't getting the services it was committed to. Can you talk a little bit about that for me?
Sure,
first?
and I'll, there are 159 counties, 537 cities in the state of Georgia, and I'm sure there are people in every one of those jurisdictions that's unhappy with the level of service that they get from their local government. That's just going to be a fact of life. Now, if you're talking about specifically my example of the hotel motel revenue, it could be that the hotels aren't unhappy with what they're getting, but somebody else in that 60% area is. But that doesn't really matter when it comes to the revenue bond, because that's a financing obligation.
Right.
And so what happens here is if that area de-annexes and something is tied to that hotel motel revenue, and that hotel motel revenue is no longer there, that financing obligation could fail, which could cause financial hardship for the city. So that's the real challenge.
What revenue bonds have been issued on hotels? Is that the hotel motel tax?
It's a hotel motel tax.
So are you concerned that all the hotels in your whole city are going to de-annex? Because it just seems like to me, this is only people that are affected on the outer skirts. They literally have to touch the county. So we're not, it seems like to me, maybe we're trying to make a mountain out of a molehill here when it's just a one-off hotel. It's not the whole city de-annexing. It's just
so I'll make two points to that. It's not necessarily one property next to a city, and it's not a property that's in the county that has an unincorporated next to it. Because again, the language in this legislation allows for the creation of unincorporated islands. This would allow for, and I hate to bring it up, but it would allow for Buckhead. And
I disagree with you, but that's fine.
Okay. So this would allow for something like that to happen. It would also allow for larger areas to de-annex, not just areas that are the properties that are right next to the city, because of the 60% method.
So one of the things you also mentioned has to do with the concerns about planning. Are you all familiar with growth boundary agreements?
I'm not.
Growth boundary?
Yeah, growth boundary agreements are typically executed between a city and a county. And they just say, these are the boundary that we're going to allow the city to grow into. Are you all familiar with those at all?
Yeah. Yeah, so if I understand, like some cities and counties have agreements as to what the zoning is going to be in the unincorporated area or whatnot next to the city.
It has to do specifically, well, if you annex into this area, we're going to have some agreements. So it's a mutual agreement that does nothing more than say, hey, we all agree to this. This makes sense. See, because to me, I think one of the things, and I'd like to hear your opinion on it, is do you believe that this legislation actually helps to assist with planning, because it really actually promotes cities and counties entering in these growth boundary agreements, which, by the way, has been done with two cities in the county and Cherokee County?
Gentlemen, if I may, I apologize for interrupting. However, we are at a hard stop at 3 o'clock, and we do have one other person asking to speak to the bill, and we've discussing with the chairman next to me here. We've decided this is going to be a hearing only, and we'll encourage the author and GMA representatives to get together offline to discuss these concerns and issues, and maybe we can bring this back up next subcommittee hearing, if that's acceptable.
Thank you, Mr. Chairman.
Thank you. Sorry about that, Representative Thomas. Thank you, sir. And now I would like to ask to come up Representative David Wilkerson.
Thank you, Mr. Chairman, members of the committee. I just wanted to come up to testify in support of the bill. I think both speakers in front kind of highlighted the issue. This has been a tug of war over the last few years between the cities and counties, and we've done a lot of work over the last few years trying to clarify the process when cities are creating annexations. But I think that what the author has done a great job of doing is trying to balance the property rights of homeowners, because right now, a lot of the issues that GMA talked about as far as leaving a city, those same issues exist when you come into a city. So the same service delivery, the same bonds that have been created, and by adding the piece in there that you have to pay for existing bonds takes care of what happens if you create debt and making sure that that debt is not left to those that are left in the city. So this is not about any one particular city. I know in Cobb County we've got our own issues, and I think this would provide an avenue, but I look at this more from a statewide issue, is that there are a lot of homeowners that are just looking for an opportunity to work with their county and cities for what they think is best for them. And by not creating islands, by getting together with your community, by doing that, I think this is definitely a homeowner-friendly bill. And I just want to say I'm in complete support of it, and thank you, committee, for listening to me.
Thank you, Representative. No questions at this point. And right now I'd like to recognize Representative Thomas just to provide some final comments before we move on to the next bill.
Well, I very much appreciate that. I think there was some, let's just say some things I don't necessarily agree about with the GMA. But one of them, I want to get back to the basics of what this bill is. This bill is about the mom and dad who moved into who was annexed into a city, and they've realized they're not getting the services that they were promised, but they're expected to pay a 20% tax or 30% tax or whatever that may be. That's just an arbitrary number for services that they're not getting. And the only way out is either one, you have to go back to the people that let you in and ask them to let you out, or it's an act of the General Assembly. And I can tell you, as somebody that tried to do a de-annexation, it is extremely difficult to get it through the General Assembly. And on top of that, what this does is it creates an alternative method that of people that are elected, and this was a comment that was made by the GMA. These are people that live in the county and they live in the city. These are elected officials, that the county elected officials that they can go to, they elect to ask for a neutral hearing where they can present their case, and the county can say, you know what, that makes sense. We can support that service, and then be allowed to be let out of the city. That's all this is. It does not stop. They can continue to go through the current process. With one small change, it does say that they need to go to whoever this is. There needs to be a resolution by the county, and that's really just, I think that's just good practice anyway. If someone's going to de-annex, the county should be okay with that. There's been some feedback with regards to health, safety, and welfare. I felt like that was a really good compromise to the GMA. I didn't have to put it in there. We could have made it at all, but you know, if this does cause problems to the people that live in that area, then there's a problem with that. The sewers or whatever that we build, they're bonded, okay? That bonded indebtedness still has to be paid for. So again, I think this is a really good, solid property rights bill. I think this is a good, solid parity between the annexation and de-annexation process. This is a piece of land. This is a piece of land, and all we're doing is talking about an arbitrary line. That's what it really the crux. So, you know, again, I'll be more than happy to work on it, and appreciate the hearing today.
Thank you, sir. All right, and next we would ask Representative Daniel to come to the front and present House Bill 409.
Thank you, Mr. Chairman. Thank you, committee members. All right, so I'm looking at LC 472195, just so we're all on the same bill. House Bill 409 will authorize local authorities basically to dispose of real property in the same manner that county governing authorities can currently. This is going to be in addition to the power that local authorities have. So we're not taking power away. It's going to be in addition to what already exists in their local law. The benefit of HB 409 is that those local laws are antiquated and often contain limited tools for sale of property as is. So, you know, I can give you a couple examples if you want them, but overall, like, we're just looking to make sure that we modernize this in a way that provides some consistency between local authorities and counties. It would allow the authorities to use a more modern, uniform, and publicly transparent method that every county in the state can use. This bill will provide greater uniformity in the law and modernize the powers of local authorities without having to amend each local law individually. Let's see. Another benefit of this is that it should provide more public awareness of the legal process to sell property, because local laws are not as readily available as the Code of Georgia is. And so the idea is that we are providing more transparency for people in terms of how property is sold. And really, it's that simple. So I ask for your favorable consideration and would take any questions if you got them.
Okay, are there any questions on the part of the committee? Seeing none, I don't think we have anyone signed up to speak to the bills, or anyone here would like to speak for about 1 minute to the bill. Seeing none, the chair will entertain a motion. We have a motion to pass? Okay, do we have a second? We have a second. Any discussion on the part of the committee? Seeing none, all in favor say aye. Aye. Any opposed? None opposed, bill passes.
Thank you.
Thank you. It'll be eligible to be called up in full committee now tomorrow, so thank you. With that, we are adjourned. Thank you.